is now in session.
Good morning, and please be seated. This is the time set for oral argument in Breonna J. versus DCS, our cause number 1CA JV210039. Counsel, I appreciate that you're both wearing masks for today's proceeding. You'll notice we are not, because we've reconfigured the bench for social distancing and also the podiums at oral argument. So it is within your discretion whether to continue to do so or not. We will respect either choice. Each side will have 20 minutes for oral argument, and if the appellant is prepared, you may begin.
Good morning. May it please the court. I'm Edward Ed Johnson, here on behalf of the mother, the appellant Breonna J. During the severance trial, the case manager was asked a simple question. And the question was, today, what circumstances keep the child from safely returning to mother's care? The case manager's response, and I quote, it's plainly mother's behavior, end quote. Your Honors, the question before you today is it appropriate and in the best interest of the public policy to terminate a parental's rights when the lingering concern is a mother's behavior, aka in this case, her attitude? I submit
well, isn't that the question though? That the difference between attitude and other one could well imagine behaviors that would absolutely support the state's position. The question is whether those behaviors are present on this record.
And I agree with that wholeheartedly, sir. Okay. I think the record indicates it's simply her attitude. There are numerous examples in the testimony, both days of the transcript, November 3rd and November 4th, as well as the exhibits that were submitted to the court, where the case manager and other providers, including psychologists, indicate that it's mother's attitude towards services. There's some debate whether or not her unwillingness to participate in services. I think ultimately they agree she's willing to participate in services. But they say that's the main hindrance, is her attitude towards others in the process does not allow her to reunify with her daughter in that case.
I thought there was evidence that indicated that the daughter was starting to have emotional problems because of her relationship with her mother.
There are some instances where that's related, but there are also other instances where she had emotional problems just in general, whether that be with her placement with her grandmother, albeit she disrupted from that placement because she was hit by grandmother, according to their records. But I know a trial there indicated that she disrupted from another placement due to her behaviors. When her and mother had a disagreement in the mall, one time it was over questionable shoes that mother, according to the testimony, indicated were white kids' shoes. At another time about the religious aspect of the child, which mother believes is solely in her right to talk to her child about religious. But I don't think it's solely to say that mother's actions affected the child, as well as the child already had some issues and behaviors on her own. And they exist today, which is why she's disrupted from multiple placements, including just recently. There's been some issues about mother's attitude, and I think one of the main things to consider is DCS's part in mother's attitude. We understand that these cases are volatile anyway. Anytime the state gets involved in removing a child from a parent, we have to understand that that's going to be some tension, at least on the onset, until the parent understands that we're trying to do what's in the best interest of the child. So it's
Counsel, do we consider the things that took place in 2006, 2007, the pneumonia, and the other, I guess, the marijuana use in front of the child? Is that something that was to be considered at the motion to terminate, the petition to terminate stage?
I don't believe so. I don't think that's appropriate. I know there could be an argument that's a totality of the circumstances, but when we're here on the motion to terminate parental rights, we're going from the active case, the case that had started from the private dependency petition filed out of family court to the actual termination proceeding itself. So I believe that, we're there obviously on what's going on as we sit there at that trial that day, but I don't think it is appropriate to take the historical context and go all the way back to the 2006-2008 time frame. I don't think that would be appropriate. Honestly, I don't think it would be fair to mom.
But I want to go back to what I was asking you before, and that is specifically, your client has a personality disorder, as has been described by the experts, correct?
Yeah, they're not sure what it is, but yes.
Okay. And that this personality disorder is the genesis of some of the issues involved in dealing with her dealing with her daughter, correct?
I believe they say that is the genesis, along with some cultural aspects that maybe weren't looked into. I think one of the doctors said that it's another specified disorder that's so new and it's not treatable, that it's not psychiatrically treatable. There's nothing they could do about it. 50% of the time, it works itself out, and the other time it doesn't, which is why he opined that there was no additional services DCS could have done to try to help mom with that. It was just essentially her working through services.
With the personality disorder.
With the personality disorder. I think he called it other personality, and then I think Dr. Jones ended up calling
Not
it.
otherwise specified? Is that
Right, correct. Judge, we think just the totality of the circumstances in this case, mother really had a hard time out of the beginning with DCS, and I'll tell you why I say that. This case manager got the case in March of 2018. I know the record says 2008, but I think that was just an error of the tongue. She got the case March of 2018, and she tells the court she's assigned to the permanency unit. And when they ask what the permanency unit is, she says basically it's when a child has no shot at reunifying with the parents. So we come aboard, sees it going to be guardianship, is going to be adoption. That was back in March of 2018. That was a long time ago. So at that time, that's what the department's direction was going to be, is that there's no chance of this child returning back home to the parents.
Is that because of mother's history?
Judge, that's really early on, but I believe they said it's because the mother was hot and cold on services. And I think admittedly, mom says she kind of stepped out, backed away when dad was doing services, or because he had the child back in the home, and I think, lack of a better word, hurt her feelings. So then she stepped away and didn't want to do any of the services. That the child was going to go with dad, and then she was out. But when that child disrupted from father and came back in, mother re-engaged in the services. So I don't know if the record really says why. It just says in March of 2018, that's when she took the case. DCS told mom to self-refer for services, and then they voiced concerns over the adequacy of the services that mother gets on her own. Of course, the VA and the DBT and the counseling that she does there. So you have a department telling mom, we're going to let you go out and get your own services so you have more faith in those services, but then they don't like the services. And when mom gets her certificates of completion, they question that and the authenticity of those certifications. They put mom in some no-win situations, including the TDMs where father's present, knowing that mother had a history of domestic violence with the father. They still had her in those volatile situations. And of course, mother gets heated, upset, and DCS ends up disconnecting mom from the TDM. There's no win situation for mother in that aspect. They were telling mom she wasn't compliant with counseling because it switched from virtual to in-person. Yet the testimony is that it wasn't Bawalda and Associates that told mom she could no longer appear virtual. It was DCS that told Bawalda and Associates that mother had to appear in person. So when mother didn't feel comfortable for doing that, and the record elicits some medical reasons why she had some concerns, DCS said, well, you're not compliant with that service. And that was right up to the trial. Judge, all of these show that mom essentially had no chance with DCS. They knew about mom's attitude, bad behaviors. It's essentially akin to putting a fox in the hen house and blaming the fox. You can't do that. DCS, for some reason, was pushing mom's buttons, almost intentionally, I think, to get a rise out of mom to see how she was going to react. And these high-stress situations, mother didn't give the response that the DCS caseworker wanted. And ultimately, the result was they asked to terminate mom's parental rights.
Do we have to accept that argument that it was DCS's fault, that they were pushing her buttons?
I don't know that you have to accept that fact, but I do think it is. It's in a record, something that should be considered when you're looking at the clear and convincing evidence.
It might be part of the atmospherics for you, but how can we make that determination as to what DCS's motivation was? And does it matter?
Well, it's another brick in the wall. I think when you look at one instance, you can kind of brush that aside. When you look at two, you can brush it aside. But when there's 3 or 4 instances, I think it's problematic. And especially in a case like this, when you know the issue is the behavior.
But sitting where we are, wouldn't we be speculating about DCS's motivation?
Respectfully, I don't think so. When you have these clear-cut instances that I don't know how you could make an argument that says that they didn't know that they didn't tell mom to self-refer. The record, page 47 on the first day of trial, they tell mom, we're fine with mom going out and getting her services. And then they question mom on the authenticity and say, no, that's not good enough. It wasn't one of our providers. Page 49, they talk about the TDM with father present, knowing that they had the domestic violence. And it says in the record, we knew she had domestic violence concerns with father. We knew that the tensions were high, but we allowed it. They didn't bifurcate. They could have. They chose not to. So I think the onus is certainly on mom. She has her share, but also it has to be shared with the department. The department has to accept some responsibility in putting mom in those situations.
I'd be concerned if you're successful here that the result turns upon an appellate court's assessment of DCS's motivations. It seems to me that your position, based just on the facts and the law, ought to be enough without our having to engage in that inquiry every time. When the next case comes up and another panel speculates, maybe you don't get the same speculation, and the law is thrown into a state of inconsistency.
Agreed, but I think here we look at the totality. So we also look at mom's compliance with the services. We note that she has completed a myriad of services that the department had asked her to do. She literally is checking off those boxes. Of course, the department's belief then, subjectively, is, well, she didn't make the behavioral changes that were necessary, so they have concerns. But mom did the services. I think the record talks about the numerous services. DBT with the VA, she completed 20 sessions. That's on page 62. The anger management to the VA, that's on page 63. She had her certificate.
Did you make, counsel, did you make that argument in the trial court that DCS was acting with not the best of motivations?
Well, of course, I wasn't there at the trial court.
Or does the record show it was made?
It does not. So I know that not directly. The attorney at the time does make some references to DCS not having full faith and credit in what mom's doing and her service and the service providers. And the attorney at the trial court did make some references to the fact that, mother tried what was in her controls given the pandemic and trying to go to in-person and virtual, and the department wasn't willing to accept those, but could have accepted those if they chose to do so.
Counsel, one, do you have any disagreement with the factual findings made by Judge Contis in this case?
I do. The factual findings were just signing off on the findings of fact and conclusion of law as regurgitated.
I don't care about the conclusions of law. I want to know if you have any disagreements with the factual findings as found by Judge Contis in this case.
I do not. I disagree with the ultimate outcome.
Okay, but
That's the application of law to
Right.
fact. Is there any reason that we should do anything other than simply accept Judge Contis's factual findings for purposes of this decision?
In my humble opinion, they're clearly erroneous. They're wrong.
Which one?
That, 1 second. So we conceded the first two portions of the 15 months time and care, but we believe that the parent has been unable to remedy the circumstances that caused the child to be in an out-of-home placement.
I think that's a conclusion of law.
a factual finding would be mother didn't do X, Y, and Z. That's a factual finding. Whether or not X, Y, and Z rises to a level, that's a conclusion.
I think what Judge McMurdy is getting at is application of fact to law. It seems to us that your position does not hinge upon the rejection of any factual findings, but rather the question whether, assuming these factual findings are correct, they meet the statutory standard.
Correct.
And so with that background is the answer to Judge McMurdy's question, that you do accept Judge Contis's findings of fact. We're not asking you to concede the result.
Thank you. Yes, I would agree. My apologies.
Okay.
So if this court were to agree with you on whether or not there was sufficient evidence for termination, what is the appropriate remedy?
Well, we didn't even get to the best interest aspect, but as the child sits here today, the child was either just recently placed or going to be placed in another home. The appropriate remedy, the child still has contact with mother. I think the appropriate remedy would be to remand it back to the court, frankly, reverse the court's decision that the evidence doesn't support the court's conclusion, and allow the family reunification to come back into table. This child was bounced around. I think the CASA report that was just submitted states the child's been in 6 or 7 different foster placements, including the one that was at trial. She disrupted from there.
Well, that's the question. If we agree with you that we don't agree with the conclusion reached by the trial court, do we simply order the dismissal of the dependency, or do we simply say, let this dependency continue?
Well, candidly, I think I couldn't in good faith say that it should be dismissed. I still think there's work to be done, and I think mother showed that she was still trying to do that work. And the counseling that was put in place, the virtual, that was working towards that, and mother said she was getting good progress on it until DCS said that's not allowed to be virtual anymore. I think it was working towards that. I think there's still some work with her and her daughter to be done in order to try to get her daughter to return home.
Well, while there may be value in continuing the reunification process under the auspices of the court, what legal authority is there for doing so? If the dependency lacks merit, do we have any choice but to dismiss it?
Agreed, if the dependency lacks merit, I would.
Do you think it does?
I don't think that the court, I don't think there's a safety risk. I don't know. I
Okay,
think
well,
mother's
let's-
minimally adequate. I don't think there's a risk to returning the child home.
Let's walk this through. If you believe that there is work to be done, then the dependency continues, and mother has not been able to resolve the dependency within the time period arrived at. So haven't you just conceded at that point in time that the severance should take place?
No, let me clarify. So what I mean to say is the department is, to the satisfaction of the department, they're not going to agree that this child can be back in mom. I'm trying to think of a case that I've had where a case was dismissed when the child wasn't living, or at least in the physical custody of the parent. And I think I have had a couple when they were out-of-state parents. It could happen. I mean, I know mother, to her satisfaction, did everything that was asked of her to do, and then some on her own. And I don't see in the record a safety concern with mother, aside from her attitude from the department. But so I think when I said that, I'm not conceding that determination at all. In fact, I think it's the exact opposite. So I clearly wasn't speaking very eloquently. So my apologies on that. So then, just real quick.
But counsel, if DCS moves to terminate, and let's say they're unsuccessful, are they allowed to keep moving every 6 months as they think that they've acquired new evidence? I mean, at what point does that end?
I don't think it ends. I think as long as they have a good faith basis in filing their motion, if something has changed from the court's ruling, I think if everything is still the same as when the court made the ruling, then I don't think they have a good faith basis to then ask for it again. But I think if there's some additional facts or there's some change in the circumstance, then it would allow them to ask and move the court to change it.
So if the dependency were dismissed now, and facts came to light that suggested that the court's involvement were still needed, the department could refile.
Absolutely.
I guess I'm trying to understand, while I appreciate your attempt to fashion a really successful remedy, I'm trying to understand the legal underpinnings for that remedy.
Well, the department absolutely, I mean, they're vested in the safety and well-being of the children of the state of Arizona. So I think if somebody
That's policy and motivation, but it's not law. Where's the legal right for the government to express its concern for the well-being of this child if the facts don't meet the legal standard?
So I would say, do I think DCS can just show up at mom's door the following a dismissal and say, we're just here to investigate and see how things are going? Absolutely not. I think statutorily DCS is obligated, if they get a call, a hotline report, if you will, that they have to investigate that. I think what you're bringing up is the exact same thing, kind of almost just as Bollock brought up in Alma S, and the concern of outreaching of the government and the DCS, and where does it stop? And I think that's a valid concern. We hear...
At least one person thinks Alma S had some valid concerns. I appreciate that.
Yeah, I mean, I think, and it's probably just stretching a little bit too much, I've done these cases for a long time, and we hear today, protect the vaccinated from the unvaccinated. Well, we got to protect the parents from DCS at some point in time. Judge Grant, who I just thought the world of a juvenile court, he once said, these DCS case managers just trample on people's rights because there's nothing that you can do about it. And I think that's a case here. The case manager didn't get along with mom, and mom's got no recourse. She can continue to kick the can down the road and try to fight it, but ultimately, mom's doing everything that she thinks she can to get her daughter back. At one point, she even concedes that she doesn't want to go forward with the trial. She's just going to do a no contest because she had heard testimony her daughter didn't want to go back to her. I mean, that doesn't show that she's a mom that doesn't care. She wouldn't be in it to win it. She's obviously doing what she can. And with that, I'll save my last minute and 45 for rebuttal. Thank you.
Thank you very much.
Good morning, and may it please the court. Oh, goodness. I'm Lauren Lowe, Assistant Attorney General, and I'm here on behalf of the Department of Child Safety this morning. Mother argues that her rights were terminated due to a bad attitude, but that's simply not correct. That's not what the findings show. That's not what the record shows.
But again, do we care what the attitude was?
No, it is irrelevant.
I still come back. I mean, your colleague has already conceded that the court's findings of fact were correct. Under our deferential standard of review, that's not surprising. So let's start there. How do we get to the legal standard from that set of factual findings?
So we get there by mother's behaviors, how her personality disorder has manifested. The record demonstrates that mother lacks insight into those behaviors, that she has them at all. But
If lack of insight were justification for parental termination, I mean, we'd have other uses for the stadium downtown.
Certainly, it's not that she lacks insight into her behaviors that's the only issue. It's that she lacks insight into how they affect her daughter, and her lack of insight has caused her to continue behaving inappropriately in a way that hurts her daughter. And I want to
Physically hurts her?
No, the risk here is not so much, as the psychologist testified, about physical harm, but about emotional and psychological harm. And I want to focus
Okay, now
on...
did she, hold on, because this is important to me. So you're talking about emotional abuse.
Not emotional abuse in the sense of, we're not alleging that mother has emotionally abused the child, which obviously is a statutory term of art that requires a diagnosis by a psychologist. We're talking about the risk of psychological harm to the child.
I do know, since I sat on a panel, that we said there is no such thing as that, a risk of emotional abuse.
So it's not so much a risk of emotional abuse, but the risk to the child psychologically. So she has been diagnosed by two psychologists with
Who has, the mother or the daughter?
The daughter, I apologize, AV.
Okay.
She's a 15-year-old girl. She's been diagnosed with a history of child neglect, child abuse, and child psychological abuse. She has post-traumatic stress symptoms, which may at some point ripen into full post-traumatic stress disorder. The psychologist identified that she has trouble identifying and managing her own emotions. She avoids trauma triggers, and that she needs stability and someone to help her address her own emotional issues.
It seems like this family is awfully lucky to incur the state's embrace in this way. I dare say that a substantial portion of the population of this state occasionally faces the emotional challenges that you're discussing, and yet the state does not come in and express its superparental concern for their emotional well-being. How did this family get so lucky?
This family has been involved with the department for quite a lengthy period of time. There were...
Whose fault is that? I mean, the department has failed, it seems to me, at every turn to prove that there is enough to merit its involvement under the law, but it does express probably meritorious concern that some of the behavior involved is less than ideal and could have deleterious consequences. If that were the standard, very few of us would pass muster.
We're not talking about a normal, problematic mother-teenager relationship. We're talking about a child who is emotionally fragile, who the psychologists have said will continue to to act out as well as regress in her behaviors and her emotional state.
So sending her to 7 foster placements is going to fix that?
Several of her placements, in fact, disrupted due to father abused her.
You understand my concern. If you say this child is fragile and that's why we're involved, let's move her around to various foster placements seems like a very poor remedy for fragility. And it also, I have not yet seen fragility as a standard in the law that allows the state intervention in this way. Without touching upon motivation, it just seems that there is a smearing of the line between objectives that the state might have for healthy child rearing and legal standards for termination. Those are two very different things, and I really don't see how the record here meets the standards for termination.
Well, we have expert testimony and expert reports that reflect the risk to AV that reflect that she has in fact already been the victim of neglect, abuse, and psychological abuse, that she has an extra need for stability beyond that of a normal teenager.
Okay, and have we achieved any of that with this proceeding? Has the state contributed to her stability one iota? Because as far as I can tell, she's been through a living nightmare, thanks to the state's involvement, that has not created stability. So even if we left aside technical noncompliance with the standards and just looked to the quality of the result, I don't see it.
The child has been in a number of placements. At the time of the severance trial, I believe it was about 5. It's important to note that not all of those placements these are not willy-nilly placements. The child was placed with her grandmother. Her grandmother eventually physically abused her, and the child had to be removed.
Counsel, let me ask you a question. So looking to the court's findings, it says mother self-referred for DBT counseling services through the VA, but continued to demonstrate aggressive, hostile behaviors towards providers and at times her daughters. What were those aggressive, hostile behaviors in that finding of fact?
So I'll give you an example of the type of behaviors that mother demonstrated toward her daughter at visitations. There's a number of visitation notes in the record, as well as just more general descriptions in the court reports. Mother would frequently get into arguments with her daughter, and obviously every teenager has arguments, but at one point, mother told the child that she did not recognize the person in front of her and that the state could keep her. Understandably, that was something that had a profound effect on AV. The visit wound up ending. She was in tears. This was not a single episode. This was a regular occurrence.
How different is that from an event in a family home where the state is not present that ends in expletives, slamming doors, and general bad behavior? That doesn't sound materially different to me. Neither is desirable, but also neither is grounds for termination.
And so, but if you could also answer my question about what that, I mean, those are adjectives.
Yeah.
I want you
Well, we're stacking questions. I've got one pending, and then Judge Weinstein.
and
I'm next.
All right, whatever. Let's just make sure we get to them all, please.
Certainly.
The adjectives there, I mean, aggressive, hostile behavior towards her daughter. I'm just asking, okay, so meetings, visitation, arguments, and a comment that you can keep her. What else?
Berating, belittling. There was raising of her voice. She was also openly lashed out at a case aide in front of AV to the point where the visit actually never occurred. And this was when the case aide was attempting to give mother constructive feedback after a previous incident that had upset AV. Mother has also, over the course of the case, boycotted visits basically in protest of what she believed to be inappropriate behaviors. She's placing her own, feelings about DCS's involvement over time with her daughter, and she actually told her daughter why she was not going to be engaging in visits. That's certainly not the sort of thing that any average teenager would respond well to, but a teenager such as AV, who has post-traumatic stress symptoms, who's much more prone to depression, anxiety, because of that, that's especially harmful to her.
So given all that, do you believe, standing as you are, that this child is better off for the state's activities over the last several years?
Respectfully, Your Honor, yes, I do. The record reflects that she was abused and neglected and psychologically abused in her home of origin. She primarily resided with her mother throughout her childhood.
So the state places her with a placement that then physically abuses her. the state moves her from placement to placement, and here we are now at the Court of Appeals years later, and she still has no permanence. Can we sit back and warmly beam at this record and say the state's really done a good job here? Thank goodness the state saved this child. I don't see it.
The focus
I see
here,
that the state has amplified this child's crisis.
So,
But I'm willing to be talked out of that if there are parts of the record I've missed.
Counsel, what about, and there's just.
Oh, I thought I had a question in here.
Go ahead.
Yeah, let's take it one at a time here.
Judge Murray.
My question is, you keep referring to this emotional abuse, but you also said to me just a minute ago that you didn't meet the definitional standard of emotional abuse, correct?
I apologize. Let me clarify, Your Honor. The doctors who saw Drs. Merkin and Huggins, they diagnosed her as having in the past been psychologically abused by mother. And that has caused her to exhibit symptoms of post-traumatic stress. The risk in the future is emotional as well. Not necessarily, we obviously don't know, we're not saying that she has been emotionally abused in the visits, but that she could suffer that emotional harm. And that's what the psychologists have testified.
Okay, so you did meet the definitional standard of abuse, emotional abuse under the statute.
For the past, yes, Your Honor. And
did
that's
those-
supported by the psychologists.
And did this, okay, so you meet under 82012, you're claiming that you met that definition. Did the trial court find that definition?
The abuse was not alleged as a termination ground.
Well, if it's not alleged, then how can that be the basis for the termination if it's incorporated in, this is what mother needed to remedy? Was that what she needed to remedy?
She needed to remedy the behaviors that were continuing to cause AV emotional distress. Those were behaviors that were a direct outgrowth of her own.
And that was contained in what pleading? If I was to look in this record to say, okay, this is the notice that you're put on notice, because we've said that they have to be put on notice, what is the record that would say this is what needed to be put on notice to you for you to remedy to get your kid out of DCS care?
Well, the private dependency petition initially alleged that mother had untreated mental health issues, and we know that her behaviors do stem from a personality disorder that has multiple particular personality traits.
That doesn't go to this part, that mother is emotionally abusing. The fact that mother has mental health issues is not whether or not those mental health issues are abusing this child, correct?
Well, I think that they are deeply tied together, because it is mother's mental health issues that cause her to act in a way that is harmful to AV. The court reports repeatedly, which mother, of course, would have access to, the court reports repeatedly note mother's behaviors with relation to AV, the effect that it has on her. As well as there were multiple hearings over the course of this case, including a Rule 59 hearing that led to the return of the child to father and not to mother, which she subsequently appealed to this court. So mother was on notice that it was her behaviors that had caused the child psychological harm, that were going to continue causing her psychological harm in the future if she continued them. She also, of course, had the child's own reactions to see how the child was reacting to her inappropriate behavior.
So I just have one other question about the findings of fact. The court says the mother's mental health condition, diagnosis, persisted for 4 years, and she's not amenable to therapy to make necessary behavioral changes. How is that, I guess, how does that fit into the grounds for termination if we accept that as a fact?
Well, so her mental health diagnosis, we've all seen parents who can parent despite having a mental health diagnosis. It's really how she addresses that diagnosis, and that relates to her behaviors. And I wanted
Doesn't the
to.
mental health, doesn't that have to impact the child in some sort of abuse or neglect?
And respectfully, the risk of emotional harm, I think, is absolutely neglect. It's an unreasonable risk of harm.
So let's say the court finds there was not clear and convincing evidence for termination. What's the appropriate remedy?
I think if you find that the record does not support that, I think the appropriate remedy would be to remand. There is ample evidence to support that the child, even if this court were to find that there's not evidence, clear and convincing evidence to support the termination ground, a dependency nonetheless still exists. This is a child who has mental health issues herself. She, in fact, between the trial and the signing of the findings of fact, was hospitalized for suicidal ideation.
How old is she?
She is 15 now. She will be 16 in November. She is old enough to need to consent to an adoption, which she is willing to do.
But has changed her position on, if I recall, several times.
I don't think the record reflects that she has changed it several times. I think
But
the
she
record.
has changed it.
Yes.
Okay.
And in fact, I think it's notable that during a child and family team meeting, the child, who I think was 14 at that time, she herself recognized that her mother's behaviors were not conducive to reunification, that this wasn't someone that she was going to be able to live with. And so her change of, her changing her mind is certainly reasonable under those circumstances. And at the time, by the time of the severance trial, she had agreed to adoption and she wished to be adopted.
I could understand almost any position a child expresses at this point. I think we've all done a lot to thoroughly confuse her.
I think mother, the most of all, has done things to confuse her. Her behavior throughout this case has done nothing but demonstrate that she is not able to parent probably not even an average teenager, but particularly this teenager. And
Is this child unsafe? Because it seems to me that this is an example of the state trying to micromanage behavior and doing so with spectacular lack of success.
yes, this child will be unsafe. The risks.
By virtue of mother or by virtue of the position in which she now finds herself in her life?
Certainly by virtue of mother, and the position that she finds
What would
herself
mother
in
do
is
there?
largely due to mother's behavior.
Okay.
The
So the visitation,
Yes.
in your minute left, they weren't visiting, it says in the order, so that they would stop fighting? And is that just the verbal sparring that you were referring to before?
There's certainly verbal sparring. It's more than verbal sparring sometimes. It ranged from simple disagreements to, this type of harmful interactions, where
Who
mom.
makes the decision whether or not it's bad enough to separate them entirely versus let them talk it out?
So the record does show varying degrees of intervention by those who were supervising the visits. They definitely attempted to separate mother and child and see if they could both de-escalate. And that absolutely did happen in some visits. Sometimes it simply was not. They were not able to do that, and so it was not viable to continue those visits. The visits here that were stopped by the end, they were not stopped at the behest of the court. It was at the behest of AV, who had initially wished to have visits with grandmother because they went better, had initially wished to have visits in the community, which would be sort of a check on mother's behavior, but eventually AV was distressed enough that she did not want to visit. That said, that is not why we are here. This is not a case where the child is, does not want to see mom, and that's why we're terminating parental rights. It would be the same even if they were still seeing each other.
Thank you.
Thank you.
Respectfully, Ms. Lowe said that mother doesn't appreciate what her emotional abuse, quote unquote, causes to her daughter. The record doesn't support that. Day 2 of trial, page 12, Dr. Jones Greenspan says, mother did acknowledge a need to be more nurturing to her daughter and to be more supportive to her daughter. It was reported that mother did report some insight. Mother also acknowledged, and this is on page 43, acknowledged she has a bad temper in the past, and I've had a bad temper in the past. But right now, I'm not as bad as I was before, and she continues to work on it. Mom expressed that she was aware that her actions hurt her child and that her words could be unnecessarily cruel to her child. Now it's page 46. But I want to read you real quick a question that the Assistant Attorney General asked Dr. Jones Greenspan. And he says, quote, can you provide a prognosis that mother would be able to demonstrate the ability to faithfully parent the child in the foreseeable future? What is that standard? That's not a standard that you can give to a parent that this doctor can opine about. That's the ability to faithfully parent the child. Judge, as this court has pointed out, this child is bounced around to a lot of different placements for a lot of different reasons. Some not her fault, some she contributed to. We have a lot of children that grew up in homes with parents with infirmities, whether it be wheelchair bound, whether it be parents with drug, substance abuse issues, mental health issues. I submit to the court that is not always a bad thing. In fact, many kids learn from that behavior and know that's not the kind of parent that they want to be. I'm one of those kids. I get to you, my parents both died very young. My mom passed away of a drug overdose. My sister died of a drug overdose. I wanted to be the exact opposite of my parent and do everything that my mom did and opposite in retrospect. This is not necessarily a bad thing. You have a mom who wants to try to be better with her daughter. Does she have work that she could have done? Yes, and she admits that, Your Honors. But this child right now, if this court upholds the decision from the trial court, this child is a legal orphan. She does not have a permanent place to lay her head. She's going to leave the system at the age of 18, and she will be a legal orphan. That's not the appropriate thing for this court to do. So we ask the court to reverse this court's decision. Thank you.
All right, thank you, counsel, for your arguments. This matter is now under advisement. A written decision will issue in due course, and we'll stand in recess to allow the next case to set up.